Okay, well, hello and welcome to today's webinar, Introduction to IPR Protection in Southeast Asia for EU SMEs. This is brought to you by the ASEAN IPR Helpdesk, and my name is Philip Healy. I manage the ASEAN IPR SME Helpdesk, and I'll be your moderator today. Joining me shortly will be our speakers of the day, our experts on the ASEAN IPR SME Helpdesk. But before we do that, let's make sure we understand the interaction tools we have at our service today in the context of the webinar. On the right of your screen, you'll find what we call the webinar interaction tool. Okay? Now, you can use this to interact with us throughout the session, and we obviously strongly recommend this. So let's give it a little bit of a spin. Let's try to gauge your attendance, whether you can hear me all right. So could you please all raise your hand using the raise hand button on the left side of the interaction tool there. Okay, so I'll be able to see if you can all do that. Ben, who's helping me on admin today, are we getting everybody responding? Okay. Well, if you have any problems in terms of the audio, or you can't quite, or you have a few questions in terms of support, please use the question log in there that you have in the interaction tool to communicate with us. Staff on board that will help troubleshoot. But of course, its main function will be to collect your questions when it comes to the Q&A, or if you have any questions during the actual presentation, please don't hesitate to reach out to us, and we'll be able to intervene live with our experts during their presentation. Okay. Well, without further ado, and before we even start talking about the help desk and go through the presentations, I'd like to introduce you to today's speakers. We have Simon Cheetham, our project team leader, and Patrice Vidon, one of our experts on the help desk, with us today. They should be both online with us, and I'll ask them to quite simply introduce themselves. So Simon, can you hear me? Are you online with us?
Yes, I can hear you loud and clear. Thanks, Philippe. Hello, everybody. This is Simon Cheetham. Just to very, very briefly tell you who I am. I have a criminal law enforcement background. I've spent 7.5 years in the Hong Kong police force, and I've also spent 17 years in Southeast Asia working on IP enforcement and loss prevention in the region. And as Philippe has mentioned, I'm a team leader of the ASEAN Helpdesk and of our sister project, the China Helpdesk. So back to you, Philippe.
Fantastic. Thank you, sir. Patrice, can you hear us loud and clear?
Certainly. Hello, Philippe. Hello, Simon. Hello, everybody. I am Patrice Vidon in Paris. A little bit chilly this morning, so sorry for the throat. So I am a European patent attorney, founded a group with more than 40 patent agents and lawyers, mainly in Europe, but we have founded 3 offices in Asia. 15 years ago, we have founded our Thai office in Bangkok, and 10 years ago, we have also opened offices in Shanghai and Hong Kong. So I'd say that's maybe a short presentation.
Thank you, Patrice. Thank you. Thank you very much. Okay, well, as you might have guessed, Simon and Patrice will be sharing the presentation today. Simon will be tackling, first of all, an introduction to the ASEAN IPR SME Helpdesk, presenting to us how this functions, what are the services that are for European small businesses, European SMEs. He'll also give us a quick general overview of the region, the main features of the Southeast Asia, of the ASEAN region, and of course tackle the most common issues and critical success factors for Europe's small and medium enterprises when dealing with IP. This will be followed by also a presentation by Patrice. As you might have guessed, Patrice will be tackling probably a little bit more depth the landscape in these 10 countries the kind of checklists you want to have as a European SME, and of course kind of highlight these issues by using a number of case studies to some of the countries and some of the issues in Southeast Asia. We'll conclude this with a bit of a take message and recommendations from Patrice. It will be followed, of course, by a Q&A session. We'd like to spend about 20 minutes in this Q&A. And really to make this worth your while, I would encourage you throughout the session to, again, to the time I talked about earlier on, to send us your questions. We'll keep them nice, and when it comes to the Q&A session, we'll put them to Simon, Patrice, and you'll be able to get your information, answers to your question live. You can do this through the task pane once again, or, and you can let Ben know who you'll be interacting with through the task pane. If you want to intervene early, that is using a mic, you know, more than encouraged, please let us know. We'd be happy to get involved. Okay, let's get started. And probably just to get a measure of who we're dealing with in terms of the audience today, we'd like to put forward a couple of polls. We have this first poll is to really understand how much you know about IP, how familiar you are with it in general. Our personal experience on the help desks in China and ASEAN help desks is that quite often USMEs do not necessarily have the most sophisticated understanding of IP. And just really maybe to understand where you're at today, once you understand it, we'd like to ask the first question. So I here will poll and ask you to respond. So let's start with the first one. How many are you with intellectual property rights? Indren, is it A, I am very familiar with IPR? Is it B, have a basic understanding of the subject? Is it C, I know it's important for my business, but struggle to understand it? D, I have no clue. Okay, so I'll leave you a couple of seconds there. Just voting. What's it looking like? So it seems as though we have already 60% of you have taken a vote. Waiting for a few more to get voting. Okay, a couple more seconds, guys. Okay, we're closing the vote, and what we have is let's see the results. We have 53% of you who are actually very familiar with it. That's fantastic. We have 36% who have a basic understanding of the subject. We have 28% who know it's important but struggle to understand it, and 3% who have no clue. Okay, so no fears. We'll hopefully we'll be tackling the issues in jargon-free.
May I make a comment?
Of course.
Patrice here. That's very interesting because we have a very well-distributed panel here today, and that will make questions interesting. I would suggest that those who are not so familiar, who believe they are not so familiar with the topic, they please do not refrain from asking questions. I understand, Philippe, that this session is more about strategy, and that's what we should discuss, strategy for SMEs. So any question is welcome, I believe. A very interesting panel anyway.
Absolutely, absolutely. Very good, a very good spread. Maybe we could move on with a second question, which will kind of get even more close to who we're dealing with in terms of the audience today, integration, the ASEAN region. Simply, do you have business dealings in East Asia? Yes, no, you plan to, or not anymore? So, similar exercise as 5 seconds ago. Let's give you a few few seconds to get in. Of course, this will both Simon and Patrice tailor their presentation even more to your understanding of the situation of IP, of the region itself, and also give us understanding what it might be geographically. So we have most of you voted now. Ben's showing us the results now. Okay, so quite a few of you are already dealing with the region. That's 41% of you. I can just again, that's 10% of you that have no dealings in South Asia, 41% that plan to, and 0% more. Once you get interest results, a very fair spread. Okay. Moving on, I'd like to leave it to Simon now to introduce us to the ASEAN IPR SME Helpdesk, the initiative itself, and see the services we offer. So Simon, it's all yours.
Thank you, Philippe. Hello again, everybody. As Philippe mentioned, I would like to now explain a little bit more about who we are at the ASEAN Helpdesk and how we can help you. And then I'll go on and give a brief overview of some of the issues worth mentioning in the ASEAN region from an IP perspective, and share with you some of the common issues and what we've learned are critical success factors for your business in or with ASEAN. So the ASEAN IPR SME Helpdesk is basically a communication and support program that's funded by the European Commission, and it provides services free of charge to European SMEs, and is there to help European SMEs in the protection and enforcement of their intellectual property rights when dealing and doing business either in or with ASEAN countries. Easy access to the helpdesk information and services is provided through a direct inquiry service. I'll explain a little bit more about that in a minute, and through an online portal that you will find is becoming increasingly multilingual. We are at the launch phase of this helpdesk. The official launch actually takes place right after this weekend, so you are amongst the very first audience to take advantage of some of the information and services that we provide. So I think you all deserve a pat on the back for participating today. In terms of the inquiry services, individual businesses like your own or SME intermediaries can submit inquiries on IP issues directly to us at the helpdesk by telephone or by email or in person, and then that will give you access to a panel of experts who work with us on the helpdesk, who will then provide an answer to your questions, giving free and confidential first-line advice. The helpdesk will also be arranging more training on ASEAN IPR protection and enforcement, both in Europe and in ASEAN countries. And these training and workshop sessions will be tailored to the needs of SMEs and will cover general IPR issues or more focused and specific challenges that affect your businesses, perhaps in different industry sectors, for example. We are communicating this support through guides in addition to the workshop seminars that we manage and organize. And these guides are being written for both industry and business-specific sectors. And we're also developing training materials addressing ASEAN IP issues by individual IP topics. And all these guides will be written in a practical, non-legal or non-technical language, so that the ordinary businessman will be able to read and understand what they say. We're also providing support through e-learning modules, in addition to these physical events and live webinars like today's event. Addressing the needs of SMEs and supporting these self-help approaches, the helpdesk services and information are designed to deliver jargon-free first-line advice on intellectual property and related issues. Moving on to the next slide, this will give you a snapshot of the kind of services that the helpdesk will be providing. These services you can look at as 5 pillars, if you like, giving a powerful combination of different mediums and resources to help support your business. Training provides a way of creating advocacy amongst key stakeholder groups. And we will be, as I say, providing workshops and webinars across both the ASEAN region and also within the European Union in different member states. So I emphasize this because if your company belongs to an intermediary organization, why not have them contact us to discuss organizing a workshop which may be relevant to you. As you can see from this slide, the help desk is developing these business tools and research publications which will be targeted to respond to the top issues that we learn SMEs are facing. And the online portal, which reflects really all the different elements in the online world, and we describe as a portal for innovation. Apart from the helpline, look out for a growing library of these guides that we are developing, as well as newsletters and articles and a topical blog with posts. So it is well worth adding this website to your favorites bar and revisiting our website frequently, because it will be changing and there'll be more and more information available there. So if I hope that gives a general understanding of what we're doing and how we plan to deliver these services. If you have any questions, don't hesitate to let me know. But moving on to take a more specific look at issues within ASEAN. I think most of us here today will be familiar with the fact that the 10 Southeast Asian countries have a substantial population, a combined population of nearly 600 million. ASEAN is a mixture of developed and developing countries and ranges from the wealthiest countries to some of the poorest in the world. GDP for ASEAN has tripled in the past decade, and ASEAN is Japan's largest trading partner after China. As ASEAN as a whole now represents the EU's third largest trading partner outside Europe after the US and China. That's with more than 206 billion euros of trade in goods and services in 2011. More and more EU SMEs are starting to work with ASEAN countries through export and import, through licensing agreements, or through involvement in global supply chains. In particular, the 6 countries from the ASEAN emerge as the EU's main trading partners, and they are Thailand, Singapore, Malaysia, Vietnam, Indonesia, and the Philippines. And the efforts of our help desk are therefore designed to concentrate predominantly on IP issues in these countries. And we understand that IPR infringement is one of the most common concerns for businesses when dealing with ASEAN nations, and its impact on European business is substantial. So taking a look at the ASEAN region, over the last few decades, countries belonging to the region all had to revise their intellectual property systems. And these revisions resulted at first from bilateral pressure of major trading partners, such as the US and the EU, and then from the World Trade Organization TRIPS agreement, and more recently from bilateral free trade agreements. And it's interesting to observe IP development in ASEAN over this period, because this group of countries covers both developed countries like Singapore, developing as well as least developed countries. And all these countries had to reform their outdated laws, which basically came from the colonial era, in a very short time. However, in comparison to the early 1980s, some differences in intellectual property policies have emerged in recent years. In Malaysia, problems remain in the enforcement sector and with the judiciary, and the Malaysian courts can get overloaded and backlogged. Malaysia is still struggling with its reputation as one of the world's most significant producers and exporters of pirated optical disc software, entertainment software. But the country has strong ambitions in the fields of information technology and biotech. The Philippines is a country with the longest tradition of intellectual property protection in the region. It goes right back to decrees introduced by the Spanish colonial power in the early 19th century. And during the more recent Marcos regime, IP protection was via presidential decrees. The Philippines was the first country in Southeast Asia to adopt a comprehensive intellectual property code following WIPO models. And Thailand is a country where intellectual property has generated much controversy in the past. I won't say anything more on Thailand here, as our expert Patrice will talk in more detail about Thailand shortly. In Indonesia, intellectual property development has also been affected by the political and economic upheavals the country has been going through since the late 1990s. And as in the past, the implementation of the laws tends to be hindered by a large number of implementing decrees that often take years to be issued. Political liberalization in Indonesia has also meant decentralization and the transfer of a greater decision-making power to the provinces and districts. And in terms of intellectual property cases, dealing with patents, copyright, trademarks, individual designs, and layout designs of integrated circuits, these are decided at first instance by the commercial courts and no longer by the district courts. The district courts remain responsible for criminal cases, plant varieties, trade secrets, and for border control measures on customs issues. The commercial courts, though, are not completely specialized on IP matters. They also cover bankruptcy cases. Brunei, as the last of the old ASEAN 6, is a small and oil-rich country, and obviously not a major player in intellectual property matters at this stage. It replaced the colonial laws providing for local re-registration of UK rights during the 1999-2000 period with a new Trademark Act and with orders on patents, copyright, industrial designs and layout designs of integrated circuits. But if we then turn from the more developed ASEAN 6 to the newer members of the ASEAN 4, the picture is rather like the old ASEAN members some 15 years ago. Just a brief mention for Vietnam, which has the most advanced system of the newcomers. Vietnam acceded to the Berne Convention at the end of 2004. The government has also prepared a comprehensive legislation in the form of an intellectual property code, and the scope is very wide, covering copyright, trademarks, industrial designs, and patents, but also business secrets and plant varieties. IP protection in Cambodia, Laos, and Myanmar is significantly weaker than in the other 7 nations. And like intellectual property rights legislation in Singapore and Malaysia is significantly more comprehensive than in the poorer, less economically active nations. So there's a sort of picture of the current status, if you will, of ASEAN. If we move on and take a look at some of the most common IP issues affecting European SMEs in Southeast Asia, from an IPR perspective, what we have learned is that some of these most common issues involve the territorial nature of intellectual property rights. European companies often fail to apply for intellectual property protection for their innovations in ASEAN countries, either through lack of understanding of the scope of their current IP protection. For example, it may be only registered in their home country, or perhaps lack understanding of the importance of registering their product at all. Another a key issue is selecting the right business partner, and I'll talk a little bit more about this in a minute. But European companies often fail to undertake proper due diligence of their ASEAN business partners, and that can result in infringement. When I talk about due diligence, all that means is doing a thorough check to make sure that the possible business partner is legitimate and who you believe they are. And perhaps another issue to highlight from this slide would be protection of trade secrets. European companies quite often fail to properly assess their trade secrets, and as a result they don't put in place sufficient measures to keep sensitive information secret, and of course that can mean it can be easily lost. Perhaps now is the best time to take a look at some of the critical success factors which are so important to EU SMEs in ASEAN. Historically, EU SMEs are just not good at registering their intellectual property rights. We seem to be behind the curve in Europe in terms of getting our rights registered. And at the help desk projects, we see many requests for help from SMEs that, you know, haven't registered their rights or didn't realize the territorial nature of intellectual property, or didn't realize that a country was a first to file jurisdiction. And in ASEAN, it's important to note that you've got both a first to file jurisdictions, for example, Thailand, and first to use jurisdictions like Malaysia. So it's important to know which a particular country is. And an overall strategy for intellectual property protection when doing business in the ASEAN region really needs to include ensuring all relevant rights are properly registered in order to give sufficient protection. One of the key pieces of advice that we try to offer to SMEs is that a layered approach is best. What that means is avoiding relying totally on one specific intellectual property right, which just gives a very narrow range of protection. With care and planning, it may be possible to exploit various aspects of your business, such as your brand name through trademark registration, perhaps copyright protecting your marketing material. And again, I mentioned finding the right partner, and this really is unto itself a critical success factor. And not just from the point of view of choosing a winning business, but also from the point of view of putting in place all the key steps which are so critical to the long-term success of your business. So you may really want to take the first step of visualizing the perfect partner that you want to work with, such as, are you going to align yourself with a big company, or where would that company best be located? Would they need to speak a European language? What sort of resources should they have, and so on and so on. All the way through to making sure that confidentiality agreements are signed, and to developing a really good sales and marketing or licensing agreement. So this has been a really quick overview of ASEAN and just some of the critical success factors. And I'd like to, before I pass on to Patrice to talk to you in more detail about IP, just to summarize with one sentence, really, and that's our key message, that it's all about your business, and these are steps for you to keep hold of your business. Thanks very much.
Okay, thank you, Simon.
Thank you, Patrice.
I guess Philippe is online, and I will now continue with our following examples I want to give. I think Simon really showed the peculiarities of the ASEAN region. Generally, as European and European businessmen, we like to see the world in big entities, in big regions. For ASEAN, as it is quite heterogeneous, as has been said, as we will briefly look at, this is really a challenge in a couple of minutes to present the situation. This is a challenge because, of course, you can't know everything on every country, every of these 10 countries. This is a challenge as well because the situation in each country is sometimes not stable, and everybody can experience a marginal experience which does not fit to the general picture. And this must be taken into account when we want to have the ambition to deal with globally with the ASEAN countries. What makes sense for northeastern countries it doesn't make so much sense for the southeastern Asian countries. For the northeastern Asian countries, Japan, Korea, China, including Hong Kong, and also the special case of Taiwan, these are countries which are now at the highest ranks in terms of IP use and IP strategy. China is now ranking first, has been so for 2 years in terms of patent filings, has been ranking first for trademark filings for more than 10 years. And all this region of Northeastern Asia indeed has completely taken into account the IP strategy. And the media generally are really 10 years behind when they want to discuss the situation in China mainland, for example. So we have some homogeneity in Northeastern Asia. We don't have such an homogeneity, like Simon has said, in the ASEAN countries. If on the next slide, you will like, for example, to the situation of the 10 ASEAN countries in terms of being a member to the key international IP conventions. I won't go into the details country by country, but you could split the 10 countries maybe into 4 categories. And we have under a given criteria, there could be other criteria, and the list could be in a different order. But let's take, for example, one criteria, which is the experience of the country in terms of IP, as I personally, through my experience, feel it. And through the cases we've been dealing for 10 or 15 years and more than 10 years in the region. First category, the 2 first countries, Singapore and Malaysia. They have been into the system for quite a time, and we'll see shortly on statistics that these countries are now in a zone quite close to even the best European countries in terms of appreciation of their IP experience and the efficiency of the IP system as seen from the European companies, I'd say, with European criteria. And interestingly, we'll see that both these countries have disappeared from the infamous list of the United States Trade Representative, which, as you know, every year mentions and distinguishes the countries where the United States believe that there are big problems for IP. Singapore has not been in the list for a very long time, and Malaysia disappeared recently of the list. So there is a reasonable satisfaction of this for the situation in both these countries. Then you would have the second category with the 3 following countries: the Philippines, Indonesia, and Thailand. All 3 countries are reasonably developed countries. Thailand even was cited as one of these dragons, and still has a very interesting economical development based on various reasons. So the IP system is developed in these countries, but is encountering problem of efficiency from the standpoint of the European company. Bear in mind that IP laws and IP system can be driven politically by a given country to achieve aims, to achieve objectives, which maybe are not the objectives of European companies, but they are their own political and economical objectives. If you remember of the United States 100 years ago, they strongly and deeply disliked IP at a time where Europe, Great Britain, France, Germany were strong industrial powers, and so the United States wanted to be on the experience curve at the time, and adopted IP laws only later on. Japan was in the same situation after the war, and then became a champion, as we know, of IP. And so all these countries have a mix, political mix, which we should understand if we want to invest in IP in these countries, and we must play with it to predict, to assess what is the situation now, and to predict when and how it can change. In the case of the Philippines, Indonesia, and Thailand, this is really a key issue. Then you would have Vietnam and Brunei, which I would put in a separate category, as these countries are not so developed yet in terms of experience of IP from the European perspective, but have made incredible progress in terms of modifying, amending the laws, and making progress. And this should be mentioned. This can be seen if you look again at the USTR infamous list. Vietnam and Brunei would be only on the watch list, the level 1 list, the list of the countries which we encourage, or the United States encourage, to improve their IP system, while Thailand and Indonesia, which are more developed in IP, are on the special list of the countries against which we have more claims, and we expect more because they are more advanced into the development of IP. Last but not least, Cambodia, Laos, and especially Myanmar are in a situation which is still developing with not so many IP developments. Let me see statistics. Laos, for example, in terms of patents, has been having a law for 20 years, but has only filed or received 200 patent applications, 200 in about 20 years or so, maybe 25 years, and none of these patents have been yet granted. So that's, of course, a situation which is quite different from even Vietnam or Brunei. Myanmar has no patent law in force at this stage, although, of course, the recent events and changes in the country will help having quite quickly a law. So that's why I would categorize the 3 countries in the bottom, in the different categories at the bottom of the list. All in all, this classification is really just one way to see it. It doesn't say anything about whether it's these countries are agreeable countries to live in, or if a business can be very successful in such a country. I just want to say that there might be different classifications possible. Let's turn now to some statistical elements. Interestingly, you will see that the statistics, first of all, you know that statistics are always not an easy tool to assess situations. You would need many curves to understand what we are speaking of, and distributing who is filing, and what means these different applications. You should take into account whether the patent law in each country has or not a petty patent or utility model, or just a simple patent of invention. So it's quite uneasy to just comment briefly the situation. But the key issue to see is that for trademarks, you would have the major countries in terms of the quantity of trademark applications filed, ranking from Indonesia to Thailand and to Malaysia. Our statistics are not fully complete for the recent years, but the trends have been continuing in this respect, and you can see that there is more homogeneity in terms of trademarks, but that I cannot see on the screen the countries which are on the bottom, but luckily you have the names at the top. But you can see that the countries which are not named on the slide are more on the bottom of the curve. If you look at design patents, you know, these tools, these legal tools which have protect the appearance of products, the outside shape of products, or even the two-dimensional designs. Then again, Indonesia, most probably due to its size, the size of its markets, and also the number of local companies, is ranking first in terms of the number of design application. And then you will find again Thailand, so the same order than for trademarks. And the third position, almost at the same level, you would have Singapore and Malaysia. And of course, this is remarkable for Singapore because the population is certainly lower in Singapore than in Malaysia. So that shows that Singapore is showing the year here as a major actor in the zone, in the region, while it did not appear immediately in the trademark curve. And very interestingly, of course, when you look at patents, and be careful again, statistics are lies or damned lies, or even worse, as the say says. The curve here is about PCT filings, so it just shows something about whether locally implemented companies will find international applications. And here, ranking first, I almost say by far, in terms of population as well, at least, is Singapore. And then is coming Thailand and Malaysia. And interestingly, at least for recent years, until recent years, we'll see for the future, Indonesia is not on the picture. So just to feel that priorities in certain countries and interest by local companies in IP and also by foreign companies in acquiring IP rights in the countries can be surprising sometimes and not directly linked to the population. And so if you are in one of these countries and having business deals, or if you plan to do so, of course, thinking of ASEAN as a global zone in terms of IP is wrong. And you should understand better for your target companies, your target country, what is the comparative situation. And if you have to make a choice between the different countries to settle, you'll have to use different criteria. The number of local IP rights being one of the criteria. You can understand that a country where you have a number of trademarks or a number of patents might have more experience in dealing with the examination and granting or registering procedure, might have more experience in the enforcement procedures. And that's what's happened in patents. Obviously, Singapore has, again, quite a big experience. Thailand and Malaysia, that might be a different story. If we look specifically at the situation of patent applications in Thailand, again, let's be careful that even though this country is ranking third in terms of patent filing, the situation looks very specific when you look at the fine prints and at the details. For patents, you'll see that, first of all, that there are three kinds of patents: the design patents, the petty patents, and the patents of invention. And you'll see that, for example, in 2011, while Thai companies and local companies are predominant in terms of filing design patents, 2,500 against 1,300 owned by foreign or filed by foreign companies. Predominance as well in terms of petty patents, the small patent, the utility models, where the inventive, the level of invention is lower than for patents of invention. This is a tool, a legal tool, mostly used by local companies. But then when you turn to patents of invention, again, figures are lies, because the situation I just lost my screen. 1 second, it's back. The situation shows that 2009 reflects the reality that foreign companies will file 4 times or 5 times more than Thai companies. And the fact that Thailand became a member of the PCT in 2010 changes figures, and so the figures for 2010 and 2011 are transitional figures where filings by foreign companies have been postponed by using the PCT route. And you'll see only in 2012 the real figure come back again with 5,000 patent applications filed through the PCT route by foreign companies, and most probably again, when we'll know the figures that will be confirmed, about 1,000 patent applications for Thai. So we find again the same distribution. The PCT route even will probably still further make the results being more unbalanced and more in favor of foreign filings. But still, having 1,000 patents of invention filed by local companies, that's not nothing. Just remember of Laos, which received 200 patent applications in 20 or 25 years. Finally, before getting to more concrete cases, because I think that's what's more interesting for SMEs, is that to have actual cases and experience and discuss on real situations, not on global statistics. I just remind you, I already touched that, maybe still go back to the USTR list. So that's this famous USC 301 report. If you don't know it, access it. Unfortunately, the EU is not making something comparative yet, but they are working on it. This gives some indication about the level of satisfaction of companies. For the US is mostly pharmaceutical and entertainment business companies in the different countries. And again, as mentioned, the priority watch list includes for Asia, ASEAN, Indonesia, and Thailand. And here, US companies, US chambers are not quite happy about the situation, but believe that the situation can be improved and work at it. And I'm happy to say that Europe is doing so also, as a vice chair of the EABC Thailand group, which is the Europe ASEAN Business Center representing companies in Thailand, and as a vice chair of the IPR working group, we certainly work hard together with local authorities to improve the situation. So we put these countries on priority watch list because we think there can be improvement, but there are problems. The watch list includes Brunei, the Philippines, and Vietnam, and as mentioned, Malaysia has been removed in 2012. So it could be said that for these countries, either the United States Trade Representative believes that the situation is better, which I don't think, or it means that they think it's something like hopeless at short term, if I may say, that it doesn't need to be on the priority watch list.
Okay, thank you, Patrice. I'm going to have to stop you there, Patrice.
Sure.
Hello, Patrice. I'm going to have to stop you there because we're running a little bit out of time, and I know that the part of your presentation, which focuses a lot on cases and issues that pertain to SMEs, is really the central point of the presentation. So let's launch this poll. This poll will also help us to further understand again audience and where you're coming from, and will help also kind of maybe help you, Patrice, know where to concentrate, in which areas to concentrate in the second part of the presentation. I apologize to everybody for the slight overrun there, but let's go through this very quickly. So, poll 3, question, what type of IP issues are you most interested in, basically? And please select one item. Is it A, acquisition of IP rights, B, enforcement, counterfeiting, C, technology transfer contract, or D, other? If it's something, please just let us know through the task and just type it in for us. Okay, we'll give you a few seconds to vote. Okay, so once again, a pretty fit with a near majority of you interested in contracts and technology transfer with 41%. But it's really split in between those who are most interested in the acquisition of IP rights and enforcement and counterfeiting with 22.7%, and others with 11%. Okay, well, let's move on. Yeah.
Quite interesting, and in fact, people are, of course, mostly interested, and that's the most strategic importance of the reason, the use of IP in order to secure technology transfers, to secure contractual relations, and not purely acquisition and enforcement. Acquisition is costing money, enforcement is costing money, and everybody would like to avoid to have put efforts in that, but technology transfer and contracts is the key issue, and that's for sure. Let's look at a couple of cases to discuss this. Before that, I just want to briefly browse what I call the basic checklist, my proposed 10 golden rules for EU SMEs in the ASEAN region, just to insist that if you want to use IP to secure your contracts or to gain an IP organization, you should know enough to make a strategic use of IP, including in the origin country, in the country of origin. You should learn enough, like we are doing today. We should exchange experience. You should have an IP policy, and mid-term and long-term policy. IP rights are rights with long durations, like 20 years for a patent, and it takes years until it's granted. 10 years indefinitely renewable for trademark. So that's long-term thinking, which sometimes businessmen forget about. You need to allocate responsibilities within the firm, so that somebody, at least two people, so that if you have one going, the other will be immediately available to take over, must have a critical mass of cases to learn how to use it strategically. You have to have an organization. You will never be able to protect your trade secrets. You will never be able to draft and negotiate and draft correct and efficient contracts if you don't have an organization. If you feel weak on that, it's not enough to be in this seminar about the ASEAN region. You need to go and sit in conferences about IP and IP organization first. And then when you have set up this strong organization, then you can refine your policies and your actions by better anticipating, filing early enough, using the procedures in the best way. And if you don't do that, maybe your competitor in Asia will do it better than yourself. So anticipating, optimizing costs, there are many ways. I mentioned the PCT route. We could mention the Madrid Agreement route or the Madrid Protocol route. There are two different protocols for trademark, international trademark protection. You have to manage deadlines. You have to use contracts to enforce your rights, of course, and to gain value through your IP rights. And of course, IP is a continuous daily work. This is to be professional. That's something very important. So let's try to illustrate this, and I hope this will raise questions from the audience. I would like next slide to look at typical IP issues in the ASEAN region, case studies. And let's go to the first case immediately I want to touch briefly, which I will call is trying to climb the north face of the issue already. How to protect softwares in one of these countries, let's say Thailand, but that can be thought vice versa in other countries. And again, that's where you will see that strategic use of IPR and full understanding of IPR laws and practices is key to have a sound software protection, because software may be protected through several routes. It may be protected through copyright. It may be protected in some instances through patents, but also it may be indirectly protected through other IPRs, like trademarks or design patents, and also database and data protection, which are two different ways and laws. And it can also be protected by trade secret, and not to speak of other ways like unfair competition or passing off a law. So if you are in the software business, you should consider all three ways, all three routes. And the third, you understand, is in fact a category with several possibilities. And copyright protection, if you have softwares, the first thing you have to do is to get the protection in the country of origin. Unless you've developed the software in the target country, Thailand in this example, where the local laws will apply for the acquisition of rights. But in most cases, a European SME will have developed the software in the country of origin, in the Netherlands, in Germany, France, wherever. And you should be careful, function of the laws of the country of origin, to organize the evidencing of your rights, because your evidencing will be from the country of origin. And that's what I've called the triple evidence, where you need to evidence that this software, and you must define it with a legal way of evidencing it. Not so easy, so you must register it in some way. This software was in your hands, was belonging to you, was owned to you, was controlled by you. I'm using specific words here. And you is a second evidence that it's about you. And you, of course, will be the company and maybe not the author of the copyright. And function of the local laws in the country of origin, you will have maybe to draft and have contracts signed in order to vest the rights into you as the company. And the third evidence is a date. So that's something you should make, and in most European countries, you won't have an administrative procedure managed by a IP office for dealing with this. It's mostly up to the software creator, the software owner, to register his rights the best way he can. In France, we would use a bailiff. We would sometimes use specific private organism which have proved to be strong enough to provide evidence recognized in certain countries, but not so easy. So that's something you should do with the copyright. I will not elaborate, of course, on all of this. I just want to illustrate that if you want to enforce and have your IP recognized in Thailand and ASEAN countries, you have first to do your homework first. Organize a legal transfer, like I've said, and also check whether your country of origin is belonging and applying the Berne Convention and how it is. You know, there are two big conventions in copyright matters, the Berne and Geneva, and that's something that should be scrutinized. That's for copyright. Patents. In Thailand, we are lucky enough that the Thai government, like most of the, I'd say, Euro-Asian continent, has adopted what the European Patent Office has set as criteria for obtaining protection of computer-related inventions. And unlike what many people think, there is quite a wide acceptation of computer-related inventions in Europe and consequently in those countries, like in Thailand, at least potentially. Just to take an example, when you look at your smartphone, you should know that you have thousands of patents have been filed on the softwares working on this. So you should consider protecting in the country of origin your software by patent and then be able to extend the protection into the target country. I guess you are pushing me to be quicker, but I would just finalize, if you quickly go back to the one, but just for 1 minute, on enforcement as well. If you want, because software protection is an example, but you will understand that this can apply to other types of goods where you need to mix the different ways to acquire the rights and you need to mix the way to enforce it. And again, we are successful in Thailand to have softwares and piracy enforced. Just you need to combine different kinds of action. You need to use open enforcement strategy and not only be on the killing side, but also being on the cooperation side. And you have many steps available to enforce your rights. And when I speak of injunctions, when I speak of investigation of computers by order of the court, when I speak of expertise, this is also valid for trademark infringements or for design infringement or for other kinds of patent infringement. So there are ways. It just needs to be professional, and of course it just needs to be worth it. Let's skip to another example. I suggest that we skip the 3 following slides and we go to the slide likelihood of confusion between trademark in Thailand. So maybe 2 or 3 more slides. I prefer to discuss this first. When you discuss trademark issues in Thailand, for example, you must, of course, understand that you will be accepted, your trademark will be registered if it's not similar to a prior trademark. And it must be understood that, like in our European countries, the similarity can be on 3 levels. It can be visual, like the first example of this kind of sphinx is showing, and here you would have a similarity even though the drawing is different, or the mountain inside a circle, that would be a visual similarity. It could be phonetic, where you would pronounce bamboo or bento and benten quite in a similar way, especially in the local language, and then you would have their similarity and no possibility to file the second trademark if the first trademark has been filed already for similar products or services. And it can be conceptual, it can be intellectual. If you think of love and amour, everybody in Europe and most probably in Asia would know both the words, even though they are not so familiar with French and English, would know love for sure and amour maybe as well. And if you would try to file the second trademark to try to take the fame of the first one, then again you would be barred because there would be a likelihood of confusion. So that applies for most of the countries. The difficulty is that function of the countries, the measure of how similar are the trademark is different. And we must say also that it's not only different between the different countries, but it can also be different between the examiners in the same country, and that can make a difference. And there, having a demonstrative local lawyer helps to defend better your case and make the difference. Going back to protection of trademarks, I would like and to signs protectable by trademark in Thailand. So maybe 3 slides back. I would like again to remind that you have 3 criteria to protect your trademark, and that's good for Thailand because I want to give you examples, but that applies also for other countries. First of all, your trademark should not be deceptive or laudatory or descriptive, and you may not obtain protection for derma cream in Thailand by decision of the Supreme Court, recent decision of the Supreme Court, because derma cream evokes clearly a cream for the skin, at least for those who knows a little bit of Latin. And that's descriptive. You may not protect it in Thailand. You may not also, and there Thailand goes quite far, prohibited signs. Of course, you may not protect national or foreign flags and emblems or representations of His Majesty the King of Thailand, the Queen, etc. But you may not also seek protection and obtain protection for words which might have in the mind of the trademark office an impact on the morality, on the public order. And here that's an interesting case where hysteria, which was for leather goods, has not been accepted because it was evoking something relating to excitement and emotional sexual disturbance. The other example here is the maple leaf of the national flag of Canada. And then there is the issue of similarity I've already touched. So not only think of prior rights and make your searches and have your searches made in the country to check whether your trademark will be registered, but also take into account that it should not be deceptive and laudatory, or should be prohibited by law, including in the appreciation locally of the public order, and there you might be a difficulty. I have another example. Yes?
Patrice, just a quick question, and this because we've received a few questions on the subject. Obviously, since we're on Thailand, some of the questions do relate to Thailand, but also to the wider region in general. You mentioned, what is protectable by trademark in Thailand and is not. But some of the questions do relate to the system itself. Are trademarks based on the registration of trademarks? Is it a first-to-file system similar to what you have in China in Thailand? Is that the case across ASEAN? Are there differences between countries? I guess we're on Thailand and trademarks here, but it'd be interesting to let us, that the audience know to what extent and what is the importance of when it comes to trademarks.
Okay, that's interesting question. The most important. So all the systems, of course, are first to file systems. Although first to file is generally used for patents, but we can use it for trademarks if one wants. That's correct, except for what the Paris Convention and what the TRIPS agreement, for those who are familiar with this, established that well-known trademarks may have precedence over further filed trademarks. So if you have a very notorious trademark, you may bar and you did not apply for your trademark in one country, we still can act. But I'm not sure many SMEs in the audience today would be able to claim a well-known trademarks, and moreover well-known trademarks in each of these countries. So again, as you said, it's a first to file. The two key things to check to directly answer the question is, one, is the country, one of the 10 countries we are discussing, a member of the Madrid system or not? If it is, you may file a Madrid international trademark, and then you will apply locally for the trademark. This is not possible for Thailand, because Thailand is not part of the Madrid Agreement, although they are now discussing to enter this into the law. Then for Thailand, you have to fight directly in the country. And here is my second information on this country. Thailand has a very specific system where they have their own trademark classification. And there is big work to be done in this country, because you have to describe your goods and services to which the sign will have to be applied in the trademark along the local classification. So that's the case for Thailand, which is a country I know best. For most of the other countries, the system would be more like the European country, especially those who belong to the Madrid system.
Right, I think Malaysia is obviously first to use. Yes, no, but I mean, I think a number of users, audiences, members of the audience asked this, obviously, because they're also concerned about bad faith registration. Is this something that you see as widespread in the ASEAN region?
Sure, sure. That's something you can see. You don't have to go to Asia to see bad faith application and sometimes registration. But again, we have tools to fight against this. First of all, the first tool is to be quick. If you intend to go in this region, first file. I mean, the cost for filing is so low compared to the cost to trying to kill the one who has stolen your trademark. Even though you are successful, you will take time and effort. So anticipate and try to file in the country early. If it's too late, we have ways. Again, most of these or all of these countries now are member to the TRIPS, to the WTO, and through the WTO they must apply international standards, and these international standards are the European and the US standards. So we may apply for getting back the trademarks when there is obvious bad faith. But if you don't have any argument, like you have not started doing anything in the country and you were really late, and still your trademark has been famous enough to be of interest to a local company who has filed it in bad faith, if you are really too late, it might be difficult or even impossible to regain it. So it's a case-by-case study. But as soon as you start to be known or to have some activity or to in a country, or you target it, or you might have an interest in this country, you should apply for the trademark, and you will save time and money.
Okay, Patrice, and just maybe to finish on those questions, I'm combining a number of questions here, and since we're on the subject of trademarks, I thought continue with role. There are obviously a number of SMEs and participants here concerned about the costs. Now, you mentioned, and I think we experienced that a lot at Helpdesk, on the China Helpdesk, on the ASEAN Helpdesk, is that a lot of SMEs are sometimes inhibited by the idea that this might be a massive chunk of their budget going towards IP protection or IP strategy, which they sometimes don't quite understand, and because of that, don't necessarily make those first quick steps to protect themselves. But, you know, just to give us an idea, give the audience an idea, how much would a typical small, medium-sized company, and I know it's very different. I know, each case is very different. But, just to give these guys a bit of an idea, how much does it actually cost to take those first steps that will ensure that you, as a small and medium-sized company, will make sure that at least, if something happens, if you is counterfeiting because you've taken these first steps, you'll be able to enforce your rights. How much does really cost? Just a ballpark figure.
That's a fair question and need to be addressed, of course. First, statistics. It is said that when it costs you one to develop, to think of a product, it will cost you 10 to develop and industrialize it.
Right.
And it will cost you 100 to commercialize it, including setting up your local company, etc. And if you keep these statistics, IP would cost you only a small 2 or 3% of the cost of the total investment, including commercial investment. So it's money, of course, in absolute, but in relative amounts, that's not that much. And how much exactly? For a trademark, you have 2 key steps. You have a first step, which is to first check who is there in the country you want to file your trademark. And you should make a first search. Like you said, first use or actual use of prior filings. And this is several hundreds of euros, I'd say, in general. And then once you've done this and you know who is there, then you will file with a strategy taking into account the existing rights locally. And that's, again, several hundreds of euros. Of course, it can cost more if you have to negotiate or if you have difficulties, but that's the order. That would be the same for design protection, so protection of the shape. When it goes for patents, you would better speak in a couple of thousands of euros or something like this. You have translation costs, you have examination costs, and that's right. But that's about this. If you compare this to the cost of developing a product to your market and to all the costs you have to invest to be in a country, you should not save on this, because that's what will make you have a success, at least prevent you from being barred to continue working. Beware that Asians sometimes are more strategic in their ways of tackling business because they need it, and more than some of our cultures in Europe. We have diverse cultures as well, so it doesn't apply to everybody. And you would have actors locally who would let you start making a business even though they could oppose your rights. And they will wait until you will have developed it for 2, 3, or 4 years. And then they will come to you with their rights and say, look, oh, whoops, I didn't see you at first, but you are infringing my patents or my trademark. And even though this patent of the trademark was filed in bad faith, you'll be in bad shape. So you should make your patent mapping and patent searches and trademark searches early, and invest in acquiring your rights, knowing what's there quite early in the process.
Okay. Okay, well, thank you, Patrice.
How much time do I have left? Because I would like maybe to touch 1 or 2 more things, Philippe.
Let's have a, maybe, if that's okay, Patrice, I know I've asked you quite a few questions. Let's have another 5 minutes of presentation, and then we can tackle some questions. And in a case the question you will kind of hide the point that you're making here. So another 5 minutes of presentation, and then let's go straight to the question Q&A.
Okay, so I will really jump from one slide to the other. The one you are seeing for Indonesia, for example, is a case where you would have the second trademark, small I box, which was recognized different from the first trademark, where you have the big I at the top of the sign and box under it. So you have countries where, even though you would have some kind of similarity, you could have coexistence in the eyes of the local authorities. So that's why you need to be early in your process to see what you will be facing here. In this case, it might not be a problem because you see that the left trademark is for electronic products, while the right one is targeting retail services. So there might be possible coexistence. In the next slide, you have another example where, on the contrary, the famous trademark Nutella in Singapore was recognized to be infringed by the Nutella trademark, which had been filed by a Singaporean coffee chain. So this Singapore company, but that seems fair to European eyes, but you wouldn't find the same situation in all countries at all time. In Asia, in the ASEAN countries, Sarika, the local companies, had to give up and let Ferrero enjoy fully their trademarks. In the next example, which I like and is a little bit funny, is what is public interest again in Thailand? You remember that you had the trademark hysteria refused because of its ambiguous sensual meaning in the eyes of the trademark examiner. Here you have a small a man, Mr. P, who is quite famous for those who know that Thailand is a country with many designers. You know that two centuries ago, the king of Thailand had Italian designers come to the palace and brought the sense of design to the country, and now it's very famous for this in jewelry, in design, furnitures and so on, and also in these kind of marketable small pictures. And here, while the trademark made no problem to be registered in the EU, it was refused in Thailand because it was felt it could hurt public interest. So that should be taken into account. Don't be too provocative, and the level of tolerance sometimes is quite low in certain of these countries. Next example, maybe just to touch and see the variety of situation. I'm lost in my papers here, but this one we saw already. Maybe is the issue of the international exhaustion of rights. Just remember that when a product has been sold in a country, you will not be able to control these products in other countries where it will be re-imported. In the case of well-known trademarks, that's the case I mentioned earlier. Even though you have not registered your trademark in the country, you can fight against a local bad faith application or registered trademark by claiming being well-known. And in this case, it was accepted. And Nivea, the Vietnam courts accepted that Nivea, that's what we say in French, I know we say Nivea, Nivea in English, are protectable and obtain protection. And more you will have situations like this, where even though you will see in the media special cases where there is blatant ignorance of well-known European trademarks in Asia, more and more, in fact, the situation is really getting better. The key issue is to fight. Many people abandon and just say it's not possible to win. The reputation of these countries is so bad. That's not true. You can see that in many cases, the European companies don't act. Just a statistic, not for Thailand, but for China, for example. When you look at civil cases in patent matters, 97% of the cases before Chinese courts are introduced by local companies, and foreign companies who complain so much almost never use the civil route to enforce their patent rights. So there is too much abandonment, and it's also possible for SME, like for a big entity, to enforce the rights. So that's maybe what I wanted to say. I will touch the last one issue, which is about Singapore. Singapore, the good student of the country. Yes, let me give you a word on translation and transliteration. Be careful in these countries, and especially Thailand, that you will not write in the Latin alphabet. Like you would also have the problem in Singapore, and you have China, and China and Singapore have a similar writing system of Chinese. And so you should be careful that when you translate or when you file your trademark, you should file it in Latin letters in the original name and original sign, of course. Peugeot should be filed as Peugeot in all these countries. But it should also be considered to file it in the local language. And here you have two ways, and you should use probably two ways, and you might have to file several trademarks in the local language, whether you would translate it or whether you will transliterate it, whether you will just simply keep the sound Peugeot will become Biaozhi, Biaozhe in Chinese, and you will have to decide how to transliterate in Thai, and that will be per year, which will be a little bit different from Peugeot in Thai, or you will have to keep the meaning or to think of what the meaning in the language of the country will be. And when you take the Mercedes-Benz translated into Singaporean or Chinese, they will choose something with the sound close to Benz, which is Benchy. But it will also mean something. You will have to choose what signs you will use for that, and that means in French galopé, so like a running horse. So just to touch this issue also of the languages. And
Patrice, is the danger there, and we've been a few questions on the subject here, and Ben's kind of passing them on to me, and the questions kind of talk about, well, what are the dangers if I don't do that? Does it mean, I mean, we're obviously familiar with this on the China help desk, of course, having followed a few cases. Is that, of course, similar to China, that the local population, the users of the mark will kind of interpret your trademark in a way that you might not want them to interpret it in, like give it a specific name that you haven't chosen? Is that one of the dangers?
Sure it is. Everybody knows who is in the region, this Japanese company who is selling beverages through vending machines. And everybody knows they are calling their beverage Sweat, S-W-E-A-T, which has a special meaning in English, of course. And everybody is laughing at the fact that this Japanese guy didn't think that if a foreigner, maybe not a Japanese, maybe a Chinese, but foreigner, English-speaking person will come by, I'm not sure he will want to buy this beverage with the name Sweat. And you might have the similar problem, which you will not understand by yourself if you're not familiar with the local language, and not to speak also the official language, but also the local slang. You know, that's very dangerous if you don't take enough care to choose your trademark. So that's the first risk. The second risk is that if you don't make this reasoning and apply for these secondary parallel trademarks, not only you will maybe have a weaker marketing effect, but you will leave the possibility for a bad faith applicant to file it. And even though you might have arguments to ultimately regain your trademark, it would have been better to file it in the first place. And you know the situation in China. That's the same in some of the ASEAN countries. If you want to enforce your rights on the coast of China, in Shanghai, in Zhejiang, in Jiangsu, that will be fine, even in Guangdong. But if you need to do it in the inland, that will be more difficult. And if you have to face this also in the inland of some of the countries in the ASEAN region, you might have difficulties. So better do it in the first place.
Okay, thank you. Thank you. Which final case? Is the single case?
Singapore. Singapore.
Okay.
Just to mention, but that would be too long to elaborate on this, that Singapore has been attracting quite a lot of investments, including from European SMEs, for two reasons. One is that the legal frame seems more familiar to European lawyers than other countries of the region. So people like to be in a familiar country in terms of laws and experience. And you remember the experience curve, which is quite high because of the number of local patents or trademarks which have been filed. Second, there is also many incentives, tax incentives to invest there, and that's one of the reasons why even R&D centers have been implemented by European companies or Western companies in Singapore. And it's also a hub when for some of our clients have local activity and they want to have a local headquarter in Asia, sometimes because they want to cooperate and have a kind of a joint venture of local partners. And they will like to lodge their headquarters and the local IP portfolio sometimes in one of these countries. And Singapore, so far, has been seen as a place which is quite welcoming on this. So I want to mention this, that there is a positive effect of having IP laws, and we try to say this to other governments in the region, to have favorable IP laws, is that this attracts investments. That's the case for Singapore. So some last messages, maybe. First, have a policy and know what you want to do, and have a policy at home. For SMEs, this is the primary and the priority message to tell. And then, if you have a strong policy at home, you will immediately understand the issues in the target countries, and you will be able to cope with local specificities. File applications early, of course, and use the priority, Paris Convention priority. Have a mid-term strategy and roadmap in tune with your business model. Sync IP at the same time you sync your accounting system, for example. That's also an accompanying tool, which is key. Study and apply local rules at a minimum, and try to have a local agent which is strategy oriented. Don't take this kind of agent which will just be administrative oriented and apply, but think how you will make the best of the local rules in order to obtain what you need at the minimum of efforts. Think of your own in-house organization. We have no time to discuss that too much, but negotiating NDAs, non-disclosure agreements, confidentiality agreements already touched by Simon, protecting trade secrets, which is an art in itself, having in-house safeguarding procedures, and at least contractually. That's very important. And manage the contracts. Many things also rely on how your employment contracts or your cooperation contracts with your local partners are drafted. And this needs care. And this is not any kind of contract. This is IP contract. So an IP specialist should have a look at it. And last but not least, enforce. Do not hesitate to enforce. Do not think it's lost. We are at this time where all these countries understand and that IP is key to development. And even the judges know that. And we are on the good side, and we just need to use the system.
Okay, thank you very much, Patrice. That was very useful, very insightful. We will launch straight into the Q&A. Really, I'm aware that it's kind of getting a little bit around lunchtime in Europe and getting a bit late in Asia. So let's go straight to a few questions. First of all, I'd like to maybe put a few questions. Those from Julien in France and Caroline in the UK, and they seem to have an issue, which is they would like to consider ASEAN as a whole in terms of their commercial entities and strategy, but because, and as you highlighted, there are differences between the protection between the various countries. They're concerned, or they don't know really where they should start, which they should register in. Should they register for this cost issue? I mean, we'll highlight these issues. So, you know, what would you, Simon, advise in terms of strategy when entering the region as a whole? Would it be a country-by-country selection? Would it be those that are the most sophisticated? Would it be what would be the safekeepers there?
Well, I would simply say that I think Patrice has made a very good point on this, and that is probably the best step you can take is to make somebody responsible for that region, because otherwise it's very difficult to categorize, you know, whether you should prioritize one country over another. It much depends on the legal infrastructure there and what your commercial priorities are, and you know, where you need to expand or be first, or where you are planning perhaps to set up a joint venture or a partnership. So without being able to consider all those factors, probably the easiest direct answer is to appoint somebody who is responsible for the ASEAN region, and in that way you will then be able to formulate the right strategy. You need somebody that they're responsible for it first.
Yeah, I think Simon is really right on this. There are two steps anyway to make. First, decide what is your strategy. Are you an IP-driven company or are you a market-driven company? And that should be decided. Most companies are market-driven. You want to access Indonesia because you know that your products will be sold and you have more chances to develop there, or you would prefer another country for some reason. So please decide what is leading. Is it the IP issue or is it the market issue? And then you will have cope with the other issue. Second, have a clear view of the local landscape in terms of IP. The first thing to do is to order a search of trademark rights close to your own name if you want to commercialize under your own business name, and to your product names. Have a look first and make a regional search to see what is the situation there. And if you have technology, make a patent search, do this patent mapping and see who is there. And that's the way to see where are the dangers or where are the opportunities. You might find potential partners with complementary rights to work with. So that's the two steps to take when you want to access the market.
Okay, well, thank you to the both of you. Obviously, that echoes what we had discussed in the presentation. We've had a number also of interventions of questions from Ricardo. Ricardo, first of all, asked if the trends in the ASEAN region are based on first file registry systems. I think we tackled that earlier on, Patrice, but there was also a question with regards to designs and how long they are protected for. I didn't get a country from Ricardo. Maybe we can ask him in which country he's referring to. But he wanted to know for how long designs are protected for 10 or for 25 years.
Okay, so that's a shorter protection time. I won't be able on the spot to tell you for the 10 countries what is the protection. Okay. But we can provide to this person the table with the duration. Generally, it's about 10 years.
Yeah. Yeah. Okay. And just to point this out and highlight it later on, for all of you that have particular questions on, how long will my registration last for, what types of patents are available in each of the countries, what languages should I use in terms of filing? All this is available in the country fact sheets that are available on ASEAN IPR SME Helpdesk website. So you to go and download a country-specific fact sheet. Okay. Now, a couple more questions here concern actually trademarks and just a simple, well, not so much simple, but a question on the differences between different trademarks. We have a question here from Fuong Kyo, I hope I'm pronouncing that correctly, who asks what is the difference between a collective trademark and trademark, and if whether collective trademarks are recognized in Vietnam and the rest of the ASEAN countries.
Very, very interesting question indeed. So collective trademark is a trademark where you have some kind of agreement between potential users of the trademark, and which makes it possible for those who will sign and comply to the agreement to use the trademark. That's the meaning of collective trademark. You know that collective trademarks are competing on the international scene, generally with geographical protection. Collective trademarks are a privately owned right where you decide to make your agreement between private parties, and once your trademark is accepted and registered and your agreement is complying to the law, you have your rights. In geographical protection are granted by the state, and generally European countries and continental Europe supports geographical protection rather than collective trademark because it looks stronger. And we must say that in all these countries, like Vietnam, like Thailand, like China, Europe has been quite influential, and all these countries have the geographical protection open, while the more Anglo-Saxon and more US system of the collective trademark was not retained as the primary route for protecting these kind of things. So you have both routes, and you may, in any case, of course, register trademarks and use them as collective trademarks in most of the countries.
Okay. Thank you much, Patrice. Okay. Moving on to the next question, we have one question from Anna in Poland, asking about copyright, and copyright is practically protected in ASEAN countries.
Sure. So here, all these countries are a member to WTO, and also they are a member either to the Berne Convention or to the Geneva Convention. Refer to one of the slides I showed, the table with the international conventions. And by being member to this, they apply the international rules, which have been used, set up and used for decades in the world. So of course there is. Concerning the new copyright treaties, so-called WIPO treaties, for those who are familiar with this, they are also in the process of being adopted in most of these countries for the copyright applying to electronic or network or these kind of goods. So it's then a case-by-case situation, country by country. But by having all these countries being members of the WTO and thus the TRIPS, the trade-related IP rights agreement, they have to, and they have most of them already complied with these international requirements.
Okay. I understand that there are a number of countries, for example, Indonesia, where it is possible to register your copyright. Now, it is something that, because it's, I believe, quite expensive, and because it might help further down the line in terms of enforcement action, that it is quite advisable to register it, even though, okay.
Yes, indeed. So some of these countries, Thailand as well, offer a possibility to register. You have one of the issues is whether you may register without disclosing too much of what you want to do. That is not too much publicly available. So you have to make a decision on the trade-off. In Thailand, I don't know for Indonesia, but for Thailand, you may register, but register recognizable parts without filing and registering the total part of it. So that makes it more sure. And as you said, it is really recommended if you believe you will have to enforce your rights, that the evidence you will show, and registration is obviously one of these evidence, is accepted by courts, the evidence will be shown locally. But it might not be enough, because the date at which you will register locally might be late compared to the date you can claim for the creation of the original creation of the copyright in the country of origin. So it can be a complementary action, but it doesn't replace, in most cases, the fact that you should show your evidences that you had the rights before and you created the right before in the country of origin.
Thank you, Patrice. Maybe here a question, there's quite a few, I know Marco from Italy pointed this out, and a few others, is the kind of the usual conundrum between kind of dealing with partners and the cultural aspect of dealing with partners in Asia, and particularly in ASEAN, or for example in China. In some cases this has come up a number of times. The fact that there's sometimes the issue of signing a contract it comes, should we sign a contract? Our partners have told us that this should be done on a trust basis. They're not too comfortable signing a contract. What should we do? We don't want to force the issue, otherwise you might lose the account. These are points that have seemed to have come up in questions throughout the webinar. What would you suggest to an SME faced with a potential partner who refuses to sign a contract?
Then forget this partner. It's very clear. For the one who will not accept to sign a contract, you don't know. You accept. If you accept what he is dictating you, you are losing not only the face, but also the control of the situation. So there is no way to believe that when you are in a country, you should do what the people in the country tell you what you should do. No. We should work under the rule of law, and the rule of law is not the rule of law, it's just making clear what you want and where you want to go. And I believe only in correctly drafted agreements, and I believe only in win-win agreements. I'm old enough to have seen so many cases. There are many tempers to make business, but the one I'm interested to advise is the one where you want to make win-win situations and build something and be of good faith in doing it. As Europeans, we are still the reference, whatever happens, and we are weighted to show this reference, and we should take the lead into dealing IP issues and do it the international way. And the international way is the one which is in the conventions. It has already been compromised and discussed at international level. Let's apply this. So don't speak with anybody who doesn't want to sign an NDA, a non-disclosure agreement. Stop. Everything you have invested might be lost at any time, and you will be in the hands of your partner. And if you don't want to have an agreement, to write down what you want, including the causa remota and the causa proxima, so the reason, long-term reason and the short-term reason why you make the agreement, then forget it, and you shouldn't do it. Not only this partner might work against you, but also he will be a dangerous partner, because by not understanding what is IP law and what is a contract, he will behave with other parties, a part of your cooperation, in the same way, and it will be a source of leakage and uncertainty.
I think that's pretty clear, Patrice. Thank you very much. Okay, well, maybe I know we're running out of time, and maybe this should be the last question. It's a little bit cryptic, I'm afraid. Maybe we can get more information from Jean-François, but he asked, is it possible, and I don't have a country in particular or anything, but he asked, is it possible to file for biotech patents or diagnostic patents?
Quite interesting. This is an ongoing question for a lot of these countries. By the TRIPS agreement, it should be accepted. But in fact, in most countries, the examination guidelines, only to speak of the examination and granting procedure, not to speak of the enforcing side, which is another story. But for the acquisition of right, we must say that it's quite fuzzy about what rules are being applied. And in Thailand, for example, we need to discuss with examiners and see, and they have to make up their mind by lack of having clear or even drafted and accepted guidelines. Moreover, I don't know which side is the one asking the question, but you have lobbies strongly acting against or towards the local governments. And you have NGOs on one side, and you have designers of genuine products on the other side. And there are many elements which have to be taken into account to predict what will be the situation in a given country. So that's very fine-tuned strategy that should be made. The situation is not an easy one. But you don't have to go to Asia and to the ASEAN countries to see this, even in Southern European countries as well. If I have a recommendation, in any case, please try. Please go for it. Please defend your business. Please start at least to make a case, even though you will be rejected later, because it will help collectively everybody, and you might win, and you might have a positive outcome. So try. That's about entrepreneurship and business.
Well, on that note, thank you very much, Patrice. Thank you very much for joining us today, which was a great presentation, hopefully very insightful to these that joined us today. A great load of information and something that we will, again, of course, we'll be planning a number of webinars for the next 15 months or so. The schedule will be available in the coming weeks. But in the meantime, I'd like to point out our recently published Helpdesk Country IP fact sheets. We've got 6 available, I believe, and with a further 4 joining the library very soon. This presentation, of course, will be available to all of you. Therefore, you're able to access the link I have here in the presentation. And you will have access, of course, to the recording of this webinar. I'd like to also point out before we leave you a number of support services, a number of regional cooperation IP projects. You mentioned EABC earlier on. There's also the ECAP projects, the EPO Virtual Helpdesk, the ASEAN Patent Informational Portal, and a number of others, all of which we will provide you with links which you will be able to access in the PDF version of this presentation, which I just told you you will receive in the coming days. And really on that note, I'd like to thank you all. Once again, our experts and team leader that joined us today. I'd like to remind you all that the ASEAN IPR the ASEAN IPR SME Helpdesk provides a number of services. We certainly encourage you to ask us your questions about IP. You can do that by contacting us at question@asean-iprhelpdesk.eu. You will receive a tailored answer within 5 days. You can also contact our colleagues in Indonesia who are taking care of the implementation of the project across the whole ASEAN region. At the telephone contact you have there at the bottom of this slide. We certainly encourage you to ask us your questions. No question is too little for us. Let's do get in contact. And on that note, I'd just like to say thank you to all. That's really it from us today. Apologies once again for going a little bit over time. Thank you, Simon. Thank you, Patrice. And thanks to all. Bye-bye.
Bye-bye.
Goodbye.